This is Attorney Jay Black of the Quattrini Law Group, and today is Legal Tip Tuesday. I would like to talk a little bit today about the Pregnant Workers Fairness Act. State and federal law have long prohibited discrimination based on pregnancy. However, these laws did not require an employer to make accommodations for limitations a pregnant employee may have. In 2023, the Pregnant Workers Fairness Act changed that. This law requires employers to make accommodations for limitations or restrictions an employee may have related to pregnancy, childbirth, or pregnancy and or childbirth related medical conditions. A reasonable accommodation can be a number of things and will depend on a number of factors, including the employee's position, the specific limitations and needs of the employee, as well as the employer's nature of business and size. An employer is required to make such accommodations unless it causes an undue hardship on the employer. An undue hardship is generally something of significant expense or difficulty for the employer. However, minor inconveniences and minor costs will not be considered an undue hardship. An employee may not be entitled to every accommodation they ask for, but the employer and employee are required to engage in an interactive process where they determine what kind of accommodation can be made for the employee to be able to do their job. The law also prohibits retaliation for someone seeking an accommodation or having used an accommodation under the Pregnant Workers Fairness Act. If you have been denied an accommodation by your employer or have been retaliated against because you either sought an accommodation or were terminated, then please contact us. Again, this has been Jay Black with a Legal Tip Tuesday.